Your Honour, my name is Nick Godfrey and I appear for the accused Marshall Ike. As previously indicated, my client wishes to plead not guilty and seeks to argue under Section 590AA, subsection 2E of the Queensland Criminal Code. We submit that my client's confessions to all charges should be excluded from evidence using the powers of the Section 130 of the Queensland Evidence Act. In particular, Your Honour, we believe that this evidence should be excluded on the grounds of fairness and public policy, the discretionary powers of which can be found at common law in the cases of the Crown v Christie and the Crown v Ireland. To the grounds of fairness, the House of Lords Christie discretion establishes that the courts may exclude otherwise admissible evidence from the prosecution which is, quote, more prejudicial than probative. This discretion was adopted into Australian law by the High Court in the 1950s in the case of the Crown v Lee, and further interpreted in the case of the Crown v Hassler by Justice Thomas, who noted that for exclusion to occur, the evidence must have relatively slight probative value, yet substantial prejudicial effect. These common law powers continue to be used today, such as the High Court's 2015 ruling of the case of Police v Dunstall. Prejudicially, we submit that Mr. Ike's confessions, by their very nature, have substantial effect, thus satisfying Justice Thomas's first element of his interpretation. Furthermore, we submit that the probative value of Mr. Ike's confession is minimal due to an apparent disregard by the police officers to his cultural status. We submit that Mr. Ike's responses to the police officers' questioning were by no means any genuine confessions, but rather examples of gratuitous concurrence. Gratuitous concurrence is widely recognised in Australia and acknowledged in the Australian Law Handbook and the Australian Bench Book. In the case of the Crown v Anunga, Justice Foster explained that many Indigenous people will, quote, answer questions by white people in the way in which they think the questioner wants. He went on to specifically note that this reaction is common when dealing with an authority figure, such as a policeman. In my client's case, Mr. Ike, only 14 and being questioned by figures of authority, was clearly nervous and simply wanted to end the situation without any conflict, so he responded in the way that he believed he had to. Additionally, in breach of Section 436 of the Police Powers and Responsibility Act, hereafter referred to as the PPRA, Mr. Ike's questioning and subsequent confessions were not recorded when it would have been practicable to do so. This further decreases the probative value. This also serves as an example of the disregard to public procedures which will inform our submissions for exclusion in the interest of public policy, which I'll get to shortly. In this sense, we submit that any confessions are significantly unreliable yet substantially prejudicial and thus, in the interest of fairness, should be excluded from the court. Moving to the interest of public policy, we refer to the case of the Crown v Ireland, hereafter referred to as the Ireland decision. The Ireland discretion, further confirmed by the High Court in the case of Bunning v Cross, grants the common law discretionary power to exclude evidence where it is being gathered through incorrect police procedures, and serves to reinforce the importance of following such procedures. In this case, police have failed to adhere to their duties set out in the PPRA, especially with regards to Mr. Ike's culture and age. Firstly, as already noted, police failed to adhere to Section 436 of the PPRA by failing to record Mr. Ike's initial confessions. Per subsection 3 of the same section, these confessions are inadmissible unless recorded pursuant to subsection 4 and Section 437. Section 436 was further breached at the police station when failure to properly record Mr. Ike's interview resulted in numerous inaudible sections of audio. Additionally, police breached Section 431, subsection 1, when they failed to properly caution my client before questioning him. Furthermore, police failed to grant Mr. Ike the access to the support to which he is entitled. A breach of Section 418, subsection 1 of the same Act occurred as police failed to notify Mr. Ike of his right to communicate with a friend, relative, or lawyer, and have that person present during his interview. Further, as a child, Mr. Ike should have also been allowed to speak to a support person of his choice in private, and that support person should have been present during the interview. Instead, Mr. Ike was simply introduced to a stranger with whom he only briefly spoke to and was clearly not comfortable with. Indeed, this support person told Marshall to answer the questions asked of him, which again, when considering the culture and age of my client, as well as the appearance of authority of the support person, could reasonably be seen as a direction as opposed to mere encouragement. In this sense, Marshall's support person directed him to waive his right to silence in questioning, a right confirmed in Section 397 of the PPRA and held at common law in numerous cases such as Pine Board Propriety Limited v Trade Practices Commission. By failing to let my client choose a support person and have that person present, the officers breached Section 421 of the PPRA, as well as Section 420, subsection 4, which affords my client the same rights as a Torres Strait Islander. On that note, the officers appeared to have failed to recognise that as my client is a Torres Strait Islander, they are required by section 420 of the PPRA subsection 2 to inform him that they had contacted a representative of legal aid, which, on the supplied facts, does not appear to have happened. With all of these breaches in mind, we refer to the 5 non-exhaustive factors set out in Bunning and Cross for the courts to consider. The first 2 principles regard whether the conduct resulted from genuine mistake. We submit that considering the numerous breaches committed, this serves as absolutely no excuse. As authority figures, the police officers in question had a duty to respect the dignity of the justice system, and clearly either deliberately committed these breaches or were negligent in their regard to procedural rules. The third principle questions whether the conduct was due to pressing circumstances. On the facts, there is no reason police could not have simply questioned Mr. Ike back at the station with a valid support person after notifying legal aid. With regards to the fourth principle, we submit that Mr. Ike's charges are not of a violent nature and violent or threatening nature, and are by no means of such a grave nature that this misconduct should be ignored. Finally, with regards to the fifth principle, what the purpose of the breach statute was, we refer to section 5E of the PPRA, which quite clearly states a purpose to ensure fairness to and to protect the rights of persons against whom police officers exercise powers. With these principles in mind, we submit that the Ireland discretion be applied and that the prosecution's evidence be disregarded. To conclude, Your Honour, we submit that the prosecution's evidence be inadmissible to the court on 2 grounds. Firstly, on the grounds of fairness and the Christie discretion, we submit the prejudicial value of the evidence is substantial whilst the probative value is minimal. Secondly, on the grounds of public policy and the Ireland discretion, we submit that the police have made numerous inexcusable blunders in arresting and questioning Mr. Ike. For these reasons, we move that Marshal Ike's confessions be deemed inadmissible. Thank you, Your Honour.